So we have the wonderful opportunity to join forces with Laura for her event series about space arbitration. Now, her first event on whether or not outer space needs arbitration was on January 13th, and it was a great success with over 350 registrations. And today we welcome you all again to another great online session. So really hats off to Laura, congratulations. For now, the fifth event organized by the Space Arbitration Association on the topic of can we arbitrate space collision cases? I will let her present the association and the idea behind the conference series, but a word on our Q&A function in this Zoom call. So we have a Q&A session at the end of the talk, so please post all your questions in the Q&A section that you can find on the lower end of your screen, and then we can take them into account. And as you just heard, we are also recording today's session. Now, last point before we start, please do keep your messages in the chat to a professional and respectful tone, otherwise we will have to take action. Now, just a quick word of introduction to SpaceWatch. SpaceWatch Global is a Europe-based online platform for information in and about space and new space activities in a geopolitical context. And I know that many of you are already familiar with our website, our bi-weekly and our daily newsletters, and our wonderful Space Cafe podcasts. And for all our fans of audio content, we also have new episodes in our Space Cafe Radio. And we're available on all major podcast platforms. Just search for Space Cafe Radio or Space Cafe Podcast. And we also keep our fan shop online open for you to support us actively and become a space watcher. And if you've missed any of our space cafes, we have an archive available on our webpage in the events section and on our YouTube channel. And with this, my job is almost done for today, and I would love to hand you over to the wonderful Laura. Thank you.
Thank you, Chiara, and thank you, Torsten, again for hosting the event. So hello, everyone. Welcome to our fifth event this year, organized by the Space Arbitration Association, and the last one before we take a short summer break until September, because we've been trying to do one per month, but the next one will take place in September. And for the rest of the year, we have planned events on the protection of investments in outer space, the new space economy, and probably on harmful frequency interference cases. I also want to take advantage of this event to tell you about the blog we have recently launched. So we now have a blog on our website, and if the blog will focus on topics related to dispute resolution and space. So if anyone would like to contribute, please send us an email, and we will be happy to post your articles. So before we start with today's event, thank you very much to SpaceWatch Global for hosting them. None of this would have been possible without you. So for everyone in the audience who is still not familiar with SpaceWatch Global, please have a look at their newsletters and the website, because it's a great resource, especially for lawyers who want to get acquainted with the space industry. I think it really provides a good overview if you're reviewing them daily. So with this, we turn to today's discussion, which I think is particularly interesting, because we will look at space collisions and on whether cases resulting out of them could be arbitrated. And I guess that most of you are probably aware that this is a very current topic, because with the increase of objects launched into space, the risk of collisions is increasing drastically. And there are not yet any clear and binding rules on how to avoid this. So there is an expectation that this might cause problems in the near future. So it's particularly interesting to address the consequences this could have in terms of dispute resolution mechanisms. And as always, we have a great panel. So we have the honor to have here today with us Professor Dr. Kai-Uwe Schrogel, who will describe the current context of space activities, the issue of space debris and relating policy issues and discussions. We have Professor Yannick Radi, who will tell us about the binding international legal framework. Catherine Doldirina, who will discuss the practical issues that space actors are facing and how they address them. And finally, we have Tim Nelson, who will tell us about the available dispute resolution mechanisms and proposals for improvement. I will introduce each of them in more detail throughout the conference, but we will now start with our first speaker, who will be Professor Dr. Kai-Uwe Schrogel. And he only sent me a very short introduction, although I'm sure I could say much more about him. But he works for the European Space Agency as Special Advisor for Political Affairs. And he is the president of the International Institute of Space Law. And he also was the chairman of the legal subcommittee of the UN COPUS from 2014 to 2016. So as I mentioned, he will tell us about the key issues in international space policy and regulation. So with this, Professor Dr. Schrogel, I hand over the microphone to you, and I will try to share your slides.
Wonderful.
So 1 second,
thank you.
please.
Thank you very much, Laura. While you put it on screen, I might thank you for inviting me to this session of your wonderful series. I would like to congratulate you and the Space Arbitration Association for setting up such an excellent framework for discussion. I should mention that we are all aware that there will be a lot more arbitration coming up in the field of space, and traditional space law, as we will discuss also today, is very restricted and a bit of shy in taking up arbitration. So it's wonderful that you and your association are looking into that. We have in traditional space law with the traditional space lawyers also a few very high-ranking and very visible personalities like Karl-Heinz Böckstiegel, who are both space lawyers and experts in arbitration. But it's extremely good that you highlight and raise the interest and the broader interest in arbitration in our field. So congratulations and thank you for your efforts. So,
thank you very much.
Yep.
Can you see the slides?
Yes, but not yeah, now it's better. Maybe you do the presentation mode and then we can go off. So I was asked by you, Laura, to look into key issues of space policy and regulation, which are related to the topic of activities in orbit, as well as the issues where arbitration might be upcoming. So I have put that into a short presentation on key issues in international space policy and regulation. The next chart, please. And there we can identify two mega trends. I would really call it mega trends because they are mega trends. But strangely enough, they are opposing each other, but they nevertheless develop at the same time. On the one hand, we are, and this is really apparent, and it has been increasing in seriousness, I would say, after the attack of Russia and invasion of the Ukraine. We are approaching an anarchy in space. I put here a question mark, but possibly this can also be replaced by an exclamation mark. We see a congested and more contested space arena. We see growing risks and threats of militarization, and also, and this is very bad to see, that the rule of law, so rule-based activities, are really under serious attack. This is an assessment which certainly is shared by a lot of people. You don't have to be really pessimistic, but even the most optimistic one see such a trend. But this is only one trend, one mega trend, I would say, because on the other hand, we see a really flourishing space economy, a global space economy, which now has around 400 billion euros or dollars per year. And this is going to approach, even with all the crises we have, with all the setbacks, and also with the anarchy in parallel, which might reach 1 trillion even before 2040. So for the next chart, you see, which has been looked at by the World Economic Forum, the areas of space activities where then the space economy and the real money is generated also. And this shows the dynamics also of the commercial markets vis-a-vis the public markets. And everything related to that will, of course, lead to issues where and situations where we will need arbitration sooner than later. Next chart, please. I will now go a little bit into the two trends and assess them and also ask what can be done. So first, the anarchy element. And the question is how to counter the anarchy. And I would propose that for countering and domesticizing a little bit the anarchy, we should regulate, and we have to regulate, the behavior in outer space. You know, traditional space law is dealing with the status of space and the status of the actors, and now we have to turn to regulating the behavior. So transparency and confidence building measures will have to be the key elements of our efforts. We have seen, and I've listed here, a number of initiatives, be they from expert groups, be they UN General Assembly resolutions, be they also, and here we come to the point of the seminar today, space traffic management and space situational awareness approaches, but also, and this is something we should not forget, the key threat to space assets is not so much the kinetic issue, but it is the cyber issue. And here we have an open field and a field which is not really neither developed on the technology side nor on the regulatory side. And there is a lot to do. And this kind of openness and this kind of intransparency will lead to more and more conflicts, in particular when things are done in a way which is aggressive. So second point I want to mention in this regard is that we also have to look, but this is more into the future, but nevertheless, we are already starting to quarrel about that, how we will use the moon and other celestial bodies. And there we have a discussion in the legal subcommittee of UN Corpus. You see it behind me, the meeting hall, where we will touch upon different and also opposing regulatory approaches as the Artemis Accords and the Chinese-Russian ILRS declaration. I have put also one point calling it security without securization. And this is something which is also, I wouldn't call it a threat, but a trend, that we have to see that a lot of activities in outer space are becoming, let's say, underneath a military and security related logic. And this, of course, when this also is entering into the field of space traffic management, for example, we have to deal with completely different ways of managing the assets and also managing the operations. And this is something which we are not used to and which also might lead to conflicts. But then I would say, as a last point in this field, we really have to take care that when we create new norms, that we do not do away with the traditional norms. And you often hear that the Outer Space Treaty and Outer Space Law is outdated and has to be revised or done away with it. No, that's nonsense. And that's absolutely wrong, because the principles of space law as I have listed them here, freedom of use, non-appropriation, and so on, they have to be maintained, because if we do away with that, it will create even more conflict. It might lead then more or less to monopolies, and also the character of a global common of outer space with a fair and equitable approach will be done away. So next chart, please. Quickly for the space economy. This is the opposing trend, a really exploding economy on all levels, upstream operations, downstream, in all fields, new space, old space, big companies, startups. So what we need in order to develop that in a good way is a level playing field with fair competition. This is key. We don't have it. We almost have no real rules for the global space economy. So this has to be established. And you see also here a number of points where we have to work on, be it intellectual property rights, be it financing, also asset-based financing, but also negative trends like flags of convenience, which we simply have to stop and we have to avoid. Next chart, please. For this purpose, IISL has also done a position paper, and typically there should not be the need for such a position paper, because we say, look, states, governments, you have to pass authorization laws, and these authorization laws have to take into account all these elements and principles I have just been talking of. But the need is there because we don't have that. It's not harmonized where it exists. And this also leads to a situation where the level playing field, which is good, then also for economic development and a fair way of shaping the global space economy, is simply not guaranteed. Next chart, please. That brings me almost to the end of my short presentation. We have to see how we also involve the private sector better into the space lawmaking and shaping regulations. And there I pointed ITU as a model for governance, because they are including non-governmental actors in a much better way than UN Corpus is doing. And again, the recurs on the traditional, I call it traditional, but it's living, the traditional principles of space law characterizing outer space as a global common province of all humankind, or however you might call it, which should avoid also the first come, first served, and avoid also the billionaires as they want and as they are, let's say, threatening us that they will be setting the rules in the future. So with that, I think that's it. Thank you very much again for providing me with the opportunity to give these thoughts at this seminar. And I'm open for questions.
Yes, thank you very much. That was very interesting. I have a few questions. You speak about space traffic management and space situational awareness. In your view, what is the state of the discussions in this regard? Do you think we are close to agreeing on an international framework, or will the anarchy prevail?
Well, we are far away from agreeing to an international framework, but we are very close to a common understanding how important space traffic management or space traffic coordination actually is. In 2016, the legal subcommittee already put space traffic management on its agenda, which is an important first step to show and to demonstrate that member states understand the need to discuss it. But so far, member states or regions like in Europe have only started to develop their positions. But as we have seen in the US, you can set out a position like the US government has done that in Space Policy Directive number 3 of 2 years ago. And Europe has been doing it with a communication by the European Commission recently, that these countries are already conceptualizing what space traffic management should look like. And this is the starting point for an international debate, because it's only good to have a multilateral approach to it. And the sooner the member states make up their minds, shape their understanding and their positions, the better it is to then start negotiations. And then it will still take years to come to reach an international consensus.
And do you think we could face a situation where the international regulation on this topic will be fragmented between the different regions? Because given the current geopolitical context, I assume it will be difficult to agree on a new international treaty, for example. On the other hand, I guess like in airspace, if it were different rules in different regions, it would also be complicated. So what are your comments on this?
Yes, absolutely. The threat is there. Of course, it only makes sense if you have a traffic management regime in outer space, which is in one shot, which really is agreed upon on the multilateral level. But nevertheless, with the current situation, we might see a fragmentation that everybody or every bloc, so to speak, is trying to find its own rules. And this, of course, will make space activities completely insecure and unreliable. Of course, the trend of a let's say best practice might prevail, but I am afraid that due to the to the confrontation on the global level, we will simply have to wait until a multilateral approach can be taken. We have been preparing studies in the International Academy of Astronautics, one in 2006 and one in 2018, together with the IISL, which provide either a bottom-up or a top-down approach. And the top-down approach is characterized by setting up a legal regime and legal architecture which might be comparable to ICAO or ITU. If you are realistic, you would say, well, this is more or less impossible currently, but in the future, it might be actually the only way to handle this issue. In the meantime, there will be ad hoc arrangements, I guess, for various and very specific issues or areas in space operations, which might be handled in a cooperative way. But this is nothing which would be comprehensive, and that should be our goal, regardless the frictions we have on the international level.
Yeah, I could imagine that there will be quite a lot of industry pressure as well to agree on a framework, because I assume that companies will want to protect their investments in space. So maybe that is part of the solution, that the pressure will come from them and not only from states.
Absolutely. We had hearings when we prepared the European position, and it was the industry and the operators who said, well, we want regulation, and you, the governments, have to take care that this is done in a way that we can operate our commercial and private space assets in a way which is safe and reliable. And they have also already started, like the Space Data Association, with arrangements, completely voluntary arrangements, which are nuclei for space traffic management. But it only concerns them, and it should be and has to be extended in the end. We also have in the World Economic Forum working groups on that, and position papers we are currently working on, where the industry is the driver. And so you are perfectly right that those who benefit and also have to rely on such a comprehensive space traffic management regime, that they are pushing the governments. And I very much hope that this will also make an impression on governments which are not so much under direct pressure and lobbying of companies. But this is a lobbying which is really good and useful. And as I indicated in my short presentation, it will be necessary to bring industry on board, because doing in this room behind me, doing something in an abstract and a very high level way amongst the governments will not be sufficient, because we need something where all the actors in space then will be joining, will be participating, and will be benefiting in the end.
Thank you very much. Very interesting. It was an honor for us to have you here today.
Thank you, Laura.
And with this, we will turn to the binding legal framework that already exists in space, and to Professor Radi, who will tell us about this. So to introduce him, Professor Yannick Radi is a professor of public international law at the University of Louvain in Belgium. And he's a guest professor of international investment arbitration at Sciences Po Law School in Paris. He is a member of the ICSID panel of arbitrators, and he is on the list of trade and sustainable development experts for dispute settlement panels under trade agreements to which the EU is a party. He regularly advises states, international organizations, and companies on international law matters, in particular on international investment law and space law. Professor Radi, we are now looking forward to hearing from you.
Thank you very much for this introduction and your kind invitation, Laura. This is a great pleasure for me to participate to this webinar and to contribute to the activities of the very dynamic association that you have founded. Congratulations again. Well, as evidenced by the presentation of Professor Schrogel, there is a crucial need to tackle space debris. Technology has a key role to play in this respect. Law has also a key role to play, and in particular, public international law, on which I will focus in this presentation. Unfortunately, as with regard to many space issues today, public international law is ill-equipped. Indeed, there is no international binding instrument which specifically tackles space debris. So in this normative context, we have to rely on instruments which were developed decades ago at a time when space debris were not at the forefront of the agenda. So put in relation to space debris, the binding international legal framework raises many interpretative questions, knowing that there is no consensus as to how to answer many of them. So in the time I have been assigned, I will discuss some of these questions, focusing successively on the Outer Space Treaty and on the Liability Convention, highlighting their potential to tackle space debris. The views I will express here are mine and shall not be attributed to any entity I am advising, of course. So before starting, I would like at the outset to flag out two key features of this international legal framework, which are relevant with regard to space debris. First of all, it is worth insisting that the current framework today is not really geared towards the protection of outer space as such, Instead, it aims primarily at ensuring that space activities can be safely conducted, and thereby fundamentally at ensuring the exercise of the freedom to explore and to use outer space. Second feature, it has an intergenerational dimension. Indeed, the regulation of space activities consists notably in balancing between the exercise of this freedom in the present and its exercise in the future. In other words, regulating space activities today aims at ensuring that outer space can still freely be used and explored tomorrow, a freedom which is clearly threatened by space debris. So keeping this in mind, let's now focus on the binding international legal framework and how it can be applied to space debris, starting with the Outer Space Convention. So for that purpose, let me share my screen with you. Here you go. So here, the article I want to focus on is Article 9 of the Outer Space Treaty, and more specifically, I want to focus on the primary rules regulating state conduct. In other words, I will not delve into procedural mechanisms, meaning consultation. So 3 points I want to flag out. First point, in relation to the last sentence you can see on the slide, it is worth noting that space debris falling on Earth and creating adverse change in the environment are not covered by this provision. Indeed, this provision refers to extraterrestrial matter. Space debris are man-made and lack such an extraterrestrial nature. Second point pertains to the due regard obligation. So state parties under this provision shall conduct their activities in outer space with due regard to the corresponding interests of all the other state parties. So such a due regard obligation exists in other public international regime, law of the sea typically. It aims at ensuring a balance between concurrent rights, and generally it materializes into a duty to cooperate to precisely reach this balance. So the incorporation of a due regard obligation in Article 9 of the Outer Space Treaty aims at ensuring that all state parties can freely explore and use outer space. It is to be linked with the obligation for state parties to be guided by the principle of cooperation, and it can also be linked to the procedural mechanism it refers to, meaning consultation. The third point I want to focus on in relation to this provision pertains to the no harm rule. Indeed, Article 9 places upon state parties the obligation to conduct exploration of outer space so as to avoid a harmful contamination and, where necessary, to adopt appropriate measures. This obligation can be linked to the prohibition under customary international law of transboundary environmental harm. This rule raises many interpretative issues with regard to space debris. Indeed, this article refers to the exploration of outer space, but not its use, which is highly relevant with regard to space debris. It begs the question of whether space debris can be considered as a contamination. And if it does, The questions arise then more generally of what a harmful contamination is, and also of which appropriate measures should be adopted. So many questions. As to the first one, there are little arguments in favor of considering that the no harm rule covers not only the exploration of outer space, but also its use. Likewise, there are arguments in favor of not limiting contamination to typically biological or chemical contaminations, but extending it also to man-made objects, space debris. Yet, it remains to determine in particular what the threshold of a harmful contamination is and what an appropriate measure is with regard to space debris. So, of course, the answer to both questions is very much case specific. That being said, from a more systemic point of view, it can be suggested as to the characterization of a contamination as being harmful, that the threshold depends partly, largely, of the degree of pollution of the orbit concerned. As for the determination of the appropriateness of the measure, it is necessary here to refer to the non-binding technical guidelines about notably the prevention of space object breakup and post-mission disposals. So such guidelines have been adopted in particular by UNCOPROS. Here I'm referring to the space debris mitigation guideline. So all these obligations, their breach can trigger state responsibility. Here, I will not address state responsibility, but I would like to focus instead on state liability, which leads me to the next part of this presentation. So the Liability Convention implements the principle which is enshrined in Article 7 of the Outer Space Convention, as you can see on this slide. So Article 7 provides for the liability of the launching state. As it can be inferred from this article, and as is made clear in Article 1 of the Liability Convention, the launching state is to be understood as the state which launches the space object, the state which procures the launching, the state from whose territory the space object is launched, and the state from whose facility the space object is launched. Irrespective of what it means exactly to procure the launching, I would like to formulate two remarks about the status of a launching state.
Just a quick interruption. The 10 minutes are already over, so just maybe if you can summarize the rest of your regards quickly so that we can move on to more questions.
Yeah, so with regard to so what I wanted to say about the launching state, but we can get back to that in more deeply afterwards, that there can be several states which are considered as a launching state, which can lead to a situation of joint and several liability. Another issue with regard to the launching state is the involvement of a private person and the extent to which their participation to a launching can lead to the liability of the host state. Then for the rest of the Liability Convention, we can discuss this during the Q&A if you wish so, but in relation to the point made by Professor Schrogl before, of course, there are principles that we have to safeguard, but I think that there is also a need to take into account the evolution known by space activities in the past decades in order to update international space law. Thank you.
Thank you very much. I will take the opportunity to answer one of the questions or to address one of the questions in the Q&A function, which was whether we think that it is good to have privatization in space, or whether the increasing presence of private companies is opposed to the principles of the Outer Space Treaty. And Professor Schrogel, if you're still there, maybe you can both address this question. Yeah, Professor Radi, you first.
Sorry, can you please repeat?
The question is whether the privatization of space in itself is a contradiction of the principles of the Outer Space Treaty, that outer space should be the presence of all mankind and maybe not of private companies.
Well, I mean, I don't think there is a contradiction between the current international legal framework and the participation of private actors. I think what is needed is to better regulate their conduct, because the focus of the international legal framework is on states, for obvious reason, given that at the time the framework was established, states were paramount. But now that we have private actors who contribute to space activities, I think there is a need to specifically tackle and regulate their conduct.
If anyone else wants to add.
Yes,
something.
Laura, if I may take the opportunity to agree with Professor Radi, it's enshrined already in the Outer Space Treaty of 1967 that private actors can be and will be allowed to conduct space activities. However, under Article 6, with the explicit authorization of a responsible state. So this was an American request to be put into the Outer Space Treaty. You can imagine that the Soviets at that time were not extremely happy with that, but it is space law. And this is one of the examples where I would say, this is good, this is excellent, and there is no need to change that. But we have to adapt, we have to add specific points, and we then have to make additional regulation in this respect. And these additional regulations are also already more or less requested by the Outer Space Treaty, Article 6, and this is that states have to pass authorization laws, national space legislation. And here we are in the current debate, and I have tried to touch that. You can only have a level playing field, not simply through an international convention, but through a harmonized set of national space legislation implementing the obligations from the Outer Space Treaty, Article 6 in particular. And this is the whole issue which we have to face. We then, it was mentioned by Yannick as well, the launching state. It was clear at the latest with sea launch that venture from many countries located in a tax haven, that we have to fine-tune and to close loopholes. And this is why we had a working group and in the legal subcommittee, and came up with a UN General Assembly resolution on the application of this concept. So I again want to stress that nothing of this, which mirrors the developments in space activities and the growing private sector, would make the space law and the status of space as and I read the question and answers and the chat, the status of space as a common heritage of mankind obsolete. To the contrary, we can maintain that, and we have to maintain that, but at the same time, we have to find the right balance of, let's say, letting privatization develop, but only in a way, and states have the full power to control that, in a way that it's not threatening the rights and interests also of the latecomers and the small and the weak, I would say. And this is the art of space lawmaking, and it can be done. We just should not be, let's say, too impressed on the one hand by the billionaires, and on the other hand by startups who are shouting away with space law because we cannot develop. That's all wrong. We will have to find this way in the middle. This sounds boring, but I think we have all the ingredients to be successful in this way.
Thank you very much, Professor Radi, for your presentation, and to both for the answers. And we will now turn to a more practical aspect of this, to look at it actually from the point of view of a company using space, because we have Catherine Doldirina here with us today. And I will introduce her with a slightly longer introduction. She told me to cut her biography, but I think it's so impressive, and I think it's good, especially for young female lawyers, to see what examples there are out there that one can try to follow. So Catherine is the legal counsel at Orbit. She's a space law expert with particular focus on intellectual property law and space activities, general questions of space law, and legal and policy issues regarding access to and use of various types of data. She joined Orbit in 2018, and her over 15-year professional experience includes a number of years of freelance consulting on space law and related topics, work as a researcher at the Joint Research Center of the European Commission, and teaching in universities in Europe and Canada. For many years, she was an active member and co-chair of the Space Generation Advisory Council. She is an active member of the International Institute of Space Law and co-chair of its International Program Committee of the International Astronautical Federation's International Astronautical Congress. And she's also a corresponding member of the International Academy of Astronautics and the legal advisor and secretary of the World Space Week Association. She speaks 8 languages, including Russian, German, and Spanish, and is a citizen of the world, and her motto is "Space is not the limit." So Catherine, this just as an example of how one can end up working at a space company, and we are now looking forward to hearing from you. And before you start with your presentation, I was going to ask you, could you maybe say a little bit about what your company is doing? Because I'm not sure if everyone in the audience is aware of this. Thank you.
Sure. Thank you, Laura, for this introduction. I'll talk a little bit about the orbit, and I will show you a little bit as well. I hope you can see my screen now. With regard to the orbit, we are a new space company and a leader in space logistics and orbital transportation. And happy to highlight that we are the world's first company to provide in-space satellite transportation services, to demonstrate satellite as a service capability in space, as well as this first space company to be certified as a B Corp, benefit corporation. And we're also registered in Italy as a benefit corporation. So our corporate purpose includes a purpose that is beneficial to society at large. And its core for the orbit is contribution to sustainable conduct of space activities. And so we are trying to model our business to contribute and facilitate sustainable use of outer space. Today, we are delivering last mile solution service for satellites, as well as payload hosting to our customers that remain in our cargo satellite. And we are also aiming to provide in-orbit services that would cover the entire satellite life cycle. And in the mid to long-term future, go into activities involving in-orbit recycling, manufacturing, and building in-space infrastructure. And here is a snapshot of some of the activities that and services that we currently offer, utilizing our ION satellite carrier. So we use it as a space taxi for our customers, enabling them to reach their target orbits much faster than using a traditional launch service. And we provide in-orbit experimentation and hence ability to acquire space heritage to our hosted space payloads, which is much cheaper than using traditional ways to launch spacecraft. And we are now preparing to move into in-orbit servicing to offer repairing, refueling, repositioning, and decommissioning services for customer satellites. And with this, I'll conclude a brief introduction of deorbit and move towards the topic of our today's discussion. And I'll start off with some consideration as to arbitrating space collision cases and damage potentially arising out of them. And here you certainly will see that I'm very much echoing Kai-Uwe and also Yannick in the sense that one of the hurdles to overcome and one of the features and characteristics that represents a challenge to arbitrating such sort of cases is the absence of a binding regulatory framework that sets out rules of the road. Because in the absence of clear rules, it is much harder to argue and to prove that one is liable for certain conduct in outer space. Also in the context of currently existing international space law and liability convention with its fault-based liability regime for damage caused in outer space. The other highlight that I would like to focus on is the reliance on contractual framework alone. So obviously, any space company, as any other company on Earth, not dealing with space stuff, operates via contracts versus its customers or suppliers. And maybe for arbitrating purposes, reliance on the contractual framework alone is not sufficient because, look at bullet points above, it may not be as complete as a dedicated regulatory framework to tap onto in order to find the best solution and adjudicate a dispute. And another, I think, area that needs to be addressed, particularly in the context of space collisions, is how to address disputes that are not arising out of contracts. because obviously the larger amount of potential cases involving space collisions would not be between two parties to a same contract that relates to an activity that is governed by that contract. And this is another issue to be quite seriously consider in order to move forward with laying ground for better framework also for arbitrating such cases. To address more generally the, let's say, business perspective on looking at arbitration versus regular national courts, I believe that arbitration is definitely more compelling and a more viable option to choose, because it allows on a substantive level to better address novel subject matter of space activities and their experimental nature by bringing dedicated and knowledgeable experts to a specific case. Also, the highly technical nature and aspects of space activities could be better treated within an arbitration procedure. And on the challenges side, I would stress again that the legal lacunae represent quite a hurdle, both, I would say, to arbitration as a dispute resolution method and the regular national courts. For instance, if I speak about the Orbit's mother company, which is an Italian company, Italy does not have a space law altogether. So the Orbit operates in a sort of a legal vacuum in the sense, and it's only up to the company itself to auto-regulate its activities and to adhere to certain standards that respect, for example, the international guidelines or follows certain requirements imposed by regulatory framework in other countries. But as a national of the Republic of Italy, the Orbit is not formally bound by any obligations with regard how it conducts its space activities due to inexistence of space law framework in Italy by and large. And if I move to procedural aspects of that play the role in deciding whether to go to court or arbitrate a case, it's obviously faster process of arbitration, the ability to select arbitrators, the confidentiality of the proceedings, and also, which I think is important within the framework of ecosystem, it is the conformity of such a choice with regard to preferring arbitration in line with choices made by other entities and important entities such as, for example, the European Space Agency. And I think such adherence and hopefully consistent practice, even if we don't know much about it due to the reasons of confidentiality, it still aids to a more coherent application even of more generic principles of law to space activities and how space-related disputes are addressed when they arise. And with this, I will conclude, hopefully not stepping over too much my 10 minutes, and thank you for your attention.
Thank you very much. That was very, very enriching to hear from someone who's actually in that position. And based on your comments, I have a question with regard to arbitration and regulation. Do you think if it were easier to arbitrate collision disputes, that this would contribute to the regulation of outer space? How would companies, for example, do you think they would adapt their behavior if there were the possibility of facing more arbitrations for unsustainable behavior in space?
I certainly think that both regulatory framework and then its implementation also by virtue of adjudicating disputes and pronouncing what behavior is right and what behavior is wrong and for what behavior one is liable is definitely contributing to a more linear and clear approach that all space actors can develop and more uniformly behave when in space and adhering sort of to the best practices that on one hand aid a sustainable use of space by reducing the number of collisions, and on the other hand forcing the space actors to avoid situations where they know that if something goes wrong, or if they are, for example, reckless, etc., that such behavior will ultimately be punishable in terms of liability for eventual damage caused.
Yes, thank you very much. And this brings us directly to the topic of Timothy Nelson, who will be our last speaker today. And he will discuss the mechanisms to arbitrate disputes that are already available. And he will also present proposals for improvement. And I think this is particularly interesting because he wrote an article that I have been quoting a lot on the possibility of including arbitration clauses into launch licenses, but I hope he will develop this further. And to introduce him, Timothy Nelson is a New York partner of Skadden, Arps, Slate, Meagher, and Flom, a US law firm, and he represents clients in US courts and in international arbitration. His cases involve a variety of industry sectors, and he has appeared as counsel in numerous large international arbitrations in venues such as The Hague, London, Singapore, Paris, New York, and DC. Within the realm of space law, he has represented clients in several international cases that raised issues of involving orbital slot and frequency allocation, as well as satellite design and configurations. He has published several articles and is widely quoted on space law, including the future of the Moon Agreement. So, Tim, if you're there, I will hand over the microphone to you.
I hope that you can hear me, Laura. The host is blocking my video at the moment. I wonder if we could do something about that.
I can hear you.
Okay, sure. I'm good. My video has started.
Now, yeah.
Good morning, good afternoon, good evening. Thank you very much for those kind words, and thank you to all of my colleagues who have preceded me and made my life simpler because I can skip over some issues. I wanted to talk, as Laura alluded to, investment law in her as the topic of a future presentation. I've done a lot of investor state work, which is a kind of international law arbitration. And I advise on a lot of commercial issues, and it's been very interesting to hear both Catherine and the two professors talk about the incentives and the need for both a mechanism for resolving disputes and for more prescriptive rules where orbital collisions are concerned. And it just struck me while we're talking about this, I won't talk about the individuals involved in heavy investment, but I would say as a whole, from my perspective as somebody who represents mainly corporate interests and investors, one of the main things to stress here is the sheer immensity of investment needed to have any kind of presence in space. That also, one also needs to bear in mind that failure unlike what NASA says in Apollo 13, failure is not an option. Failure is an actuality. Failure happens. And for that reason, that brings in not only the entrepreneurs, but it also brings in insurers, and it brings in bankers, and it brings in the risk mitigators. And those are the kind of people who are very keen to see certainty in regulation. So even if you had a very risk-prone investor at the very outset, it won't be long until you have a population of participants in the area, and we do already, that crave certainty. Certainty of what the law says and what the rules say. And I was particularly interested to hear what was said earlier from one of the professors about first of all, that there is space law. It exists. You can't wish it away. But also, even if you don't have a prescriptive rule on orbital collisions, international law will supply it. And I'd much rather be talking to a board about a code or a regulation or a treaty which clearly says what the rule is, rather than show them a slide about the 1940 trail smelter arbitration that established between US and Canada, that established the due regard rule. That is not a conversation I'd want to have with hard-headed investment bankers and venture capitalists. They ask me what I'm doing. But the other thing which brings me to my slides is that you will, if you're an investor, crave certainty of venue, I believe. And that's why I want to just, if you can see my slides now, I want to go through a few issues about arbitral venue from a very practical perspective. Let me just begin by saying that if you run the boards and the famous, there's a famous 5 treaties in space law that every student has to learn about. I'm accustomed to going through treaties to look at the second last article, which is usually dispute resolution. And surprise, surprise, there aren't many dispute resolution articles in the constellation of space treaties. Outer Space Treaty, for very good reason. It was a great treaty, and it's the anchor treaty, but it doesn't have a dispute resolution provision, which means the Lux Moot Court always has to invent a compromise between 2 parties in order to have the students moot. The Liability Convention of 71 does have a form of dispute, and I've actually got the Roman numeral wrong there. I see it's articles 14 through 20 of the Liability Convention, not 19 through 20. The Liability Convention of 1971 that sets up certain rules about damage to either the ground or in-orbit collision situations does provide if a claim for damages goes unsatisfied for a year, for the creation of a claims commission, which is a sort of a relatively unsophisticated interstate body, but it also contemplates some litigation could be pursued in the courts of a launching state, which might not always be appetizing. But the claims commission there's no standing claims commission. It's an aspiration that the states involved in the dispute will create a claims commission without a real binding framework for it to exist. So it's sort of a half an idea, but it's not there. The Moon Agreement rather lightly provides for consultation to occur if disputes arise, which doesn't help you much. And the other treaties, which are less important for our present purposes, don't have any dispute provisions. So that's leaving players without a preset place to have disputes handled. Now, just before I talk about the theme that Laura was alluding to, that you could prescribe or you could find ways of getting people to agree to arbitration in advance of launch, why would you do it? The boardroom I've just described, the hypothetical investor or the hypothetical government organization, why would they want arbitration? Well, this is pretty basic to most people on this webinar, but I'll just run through it. It's a self-contained and neutral proceeding. It's adjudicative. It's not mediation. It's not conciliation. It's a way of applying law to the facts through reasoned analysis. There are enforcement mechanisms available for many, if not most, forms of international arbitration award if you can fit it within the 1958 New York Convention on the recognition and enforcement of foreign arbitral awards. That requires the agreement to arbitrate be in writing, and various other. A lot of states require that the dispute be commercial in nature before they adhere to the treaty. But I think you could probably fit most of what we're talking in there. Arbitration allows for party input and autonomy insofar as there is participation by the parties in who the arbitrators are, which with, of course, the third arbitrator being neutrally appointed. I would say that if you go back to the Liability Convention of 1971 and some of the assumptions in old space law, there's often a very state-centric assumption in space in the older instruments, such as the 1971 Convention, which means that it contemplates not arbitration between private individuals, but arbitration between states representing the interests of the private individuals. And there may be a point where we need to get past that because it's not always the most efficient way of litigating. Arbitration also provides some cover for privacy and protection of commercial information. That is a topic unto itself, but in principle, you can keep documents under seal if you're in arbitration and keep prying eyes away. There was an initiative about a decade ago by the PCA that created what were called optional rules for arbitration of disputes relating to outer space activities. The main innovation there, or the main feature there, these rules were pretty generic, except that they started talking about having a list of persons who would have expertise in space disputes and a list of technical people. So it was a welcome initiative. And a lot of people in the arbitration space said, is this a solution in search of a problem? And I think the answer based on today's talk is no. It is, although the PCA's optional rules for space disputes haven't, pardon the pun, taken off in a big way, it is correct to say that there is a need for some sort of mechanism for resolving space collision disputes. And this may well serve that need. The problem is, and I'll get to this in a sec, the mere fact that PCA has promulgated these rules doesn't make them binding. There has to be a way of binding people to arbitration. I just want to, I'll skip over the first point here about the main legal precepts pertaining to arbitration. I've already talked about how a lot of the early treaties are sovereign-centric. But the next point is absolutely vital, that as a matter of international law, states launching, receiving, whatever they may be, can't be made to arbitrate disputes unless they have agreed either in advance of the dispute or after the dispute crystallizes to arbitrate them. You just can't have arbitration sui generis. And the same is true in most national legal systems. Nationals of a state you can't be plucked off the street and made to arbitrate your disputes. You have to sign something that says, I agree. The only exception being, and this is just worth noting, in international law, in the United States at least, if you have particular disputes with particular states, there is some law that says that they can be sent to a designated claims commission. So maybe there's a role there for claims commissions, but I won't get, I don't have the time to go into that in great detail. So the question is, how do you create a mechanism that binds people to the arbitration that we've all been talking about? One is a straight amendment to the Liability Convention or other conventions that provide for this. The trouble about amending it or creating a protocol for dispute resolution is once you start negotiating one aspect of a treaty, you open up the can of worms as to what other provisions people want to renegotiate, and you can be there forever. You could expand the PCA's initiative somehow, go state to state, knock on doors, and start trying to get people signing up to the optional protocol as a matter of principle. I don't know if that'll work. You could enact sort of uniform domestic legislation, providing that if you engage in space activities, you have to sign up in advance to arbitrate disputes, or you could create a special tribunal for the arbitration of disputes that the legislation embraces. And the fifth, which was, Laura correctly identified that when Henry Hertzfeld and I did our article about 9 years ago for the ISL on this issue, we started saying, well, there is a further alternative, which I've called here the moral suasion or the insurer alternative, the adult in the room who will force people to do adult things. You could make, either by moral suasion or by talking to the insurance companies or by talking to governments, you could make it a condition of launch or of getting a license that in order to be allowed to participate in space activities, you have to agree in advance to arbitrate. Why would, and getting back to my original question, why would you want to? Why would you agree to that? And this assumes a lot of activity at the grassroots level by governments, regulators, and private actors like banks and insurance companies that want the certainty. Why would you do it? Well, I'll just end with the following. I happen to be an Australian, and one of my first encounters with space as a child was following Skylab as it was falling. And it fell on Western Australia in a town called Esperance. And so I would say to everyone who's reluctant about arbitrating, fortunately, it fell on empty ground and it became a tourist attraction, the site of Skylab in Western Australia. But say it had hit a house or a city. Okay, say it was serious damage. Say if it hit another satellite. Would you rather be litigating the effects of that collision in the courts of Esperance in Western Australia with angry homeowners, or would you rather have international arbitration? I think the answer is pretty obvious. And by asking it in that sense, I think, although I've used the folksy example of a town in Western Australia that got hit by Skylab, I think the same principle applies across the board to any kind of collision, and therefore it applies to orbital collision issues. Would you, if you bump into a Russian satellite, or would you rather be litigating in Russia or in international arbitration? Question. I think I know the answer. So I think there are ways, if you think creatively, of encouraging arbitration in this space. You have to bear in mind the intrinsic limitations and the absolute requirement of consent. But I think we're in a place where we can very much talk about this and find a receptive audience. So, Laura, that's my parting thought.
No, thank you very much. And I think going back to what Catherine said, it seems that even from a company point of view, there might be agreement on the fact that it would be better to have clearer rules, and maybe consent to arbitration could form part of it. We don't have much time left, fortunately, rather. I've seen that most of the Q&A questions have been answered in writing. So maybe we can open the floor to the panel to see if anyone has a comment on the proposal that Tim made, to maybe find a way of having mandatory consent to arbitration for outer space activities. Do you think that could be viable? I know someone start.
I think that's one for one of our other panelists, right?
Yeah, maybe that's true. Maybe Catherine, if you have a thought on this, do you think there would be opposition from private companies to having a mandatory arbitration mechanism, or in view of the anarchy in outer space, this might be something that could be interesting?
I think it's always important to leave enough freedom to operate on all levels, right? Not only on how you conduct business, but leaving you to the freedom to decide how you want to go into a dispute. So I'm not sure it would be a one-fit-all solution to make arbitration mandatory. But I think that, my apologies, but I think that with the development of the regulatory framework, it will be also more streamlined and easier for regular courts to address these issues as well.
Thank you.
Yeah, maybe if I can step in. Can you hear me?
Yeah.
Yeah. I mean, listening to Tim, I mean, it's striking how the discussions that we are having about legal certainty, about which dispute settlement mechanism is more appropriate. I mean, this is a discussion that we have had for decades in investor-state arbitration, more generally. So I think there are lessons to be learned from history in this respect. And taking into account the situation of anarchy we are talking about, there is clearly a need for a dispute settlement forum, but arbitration, because of its ad hoc nature, the flexibility that characterizes it, can be in a way the best option as compared to a permanent institution at the international level, for instance. So I think that in times of anarchy, arbitration is pretty well equipped to adapt to the current situation. It has a great flexibility, which can be very useful in such a context.
If I may add to that, I completely agree with Yannick. This is a convincing case, and it was also made by Catherine and Timothy, and I very much liked Timothy referring also to the IISL Manfred Lachs moot court, where we have to kind of invent a way of handling these things. But even more important, you mentioned the Claims Commission of the Liability Convention. We have never tested it. So this should be, I guess, the first try. Even with the Cosmos 954 accident in Canada, it was not the Claims Commission which led to settling the situation and the claim actually Canada brought to the Soviet Union, but it was outside any such formal arrangement that the Soviet Union at that time paid, I don't know how much, a number of millions of dollars to Canada. So we are still waiting for the Claims Commission, which is there and which is binding law to the state parties to the Liability Convention. And Liability Convention has quite a few state parties, practically all spacefaring nations, that we should give it a chance to see what it can do. And then it's obvious for us, as Timothy, you point out, there should be an additional protocol or any kind then to make it appropriate to what we now have as potential issues. But I think also the awareness that we have the Claims Commission should be brought much more to the attention of the states, the governments, and the decision makers.
Tim, I don't know if you want to.
I agree. I completely agree. And of course, it would have been interesting had in my Skylab example, you might have had the courts may have been incapable of determining the issue because Australia would be bound to participate in the Claims Commission. So I do agree with that. I think it's important for people to understand that the Claims Commission model is, as I understand it, state to state. And for instance, if it's an American claimant, we would have to go down to Washington to talk to the State Department, and they'd have to dust off their guidebook as to how to pursue diplomatic protection claims, which they haven't done in a few decades. And it would have to be hand in glove with private actors and regulators. That's the model that's in there at the moment. If you had a protocol, and I think this is something Yannick was, I think, alluding to, if you had any kind of modernization through a protocol of the Liability Convention, you might want to look at the Claims Commission model and ask whether there's a more direct way of handling claims nowadays so that the real parties in interest can sit at the table.
Yeah, no, I agree. I think we could continue debating this for a while. Unfortunately, we are out of time, so I will hand back the microphone to Chiara. And thank you all very much for participating, for joining the webinar. Thank you.
Thank you, Laura.
Thank you so much, everyone, for this really amazing session. Thanks again. And as Laura already said at the beginning, be on the lookout for the next Space Arbitration Association event come September. But before we leave you for today, we also have some very exciting Space Watch events coming up. So on the 12th of July, we'll actually have our very first Space Cafe Israel by Meagher Pariente, who will be talking with Tal Inbar on the topic of Israel from a startup nation to a space nation. Then on the 21st of July, we'll have our next Space Cafe Italy by the wonderful Dr. Emma Gatti, who will be talking with Cinzia Savada. And then on the 11th of August, we will be having our Space Law Breakfast with Stephen Freeland and his guests Annie Hanmer and Chris Johnson. But this time at a bit of a different time for our American friends, so it will be at 12:30 p.m. CEST. On the 16th of August, our summer break of the 33-minute format will be over, and we will be having a exciting guest, so stay tuned for that. And on the 17th of August, we'll have our next Space Cafe Austria by the wonderful Judith Delaney. We'll be talking with Christian Plush. And as always, all our events are going to be online on Eventbrite. And we love your feedback, so please do check in with us on Twitter, Facebook, and LinkedIn. Don't forget to sign up for our daily or bi-weekly newsletters. And if you want to treat yourselves to something special, become a Space Watcher today or help us out in the supporter program. Again, huge thank you to Laura for another fantastic event, and thank you to all your amazing guests for this inspiring talk. I hope that you all stay safe and stay healthy. Again, also, thank you for joining us. Thank you for being so active in the chat and the Q&A. I hope to see you in the next weeks. And in the meantime, visit our website, follow us on social media, and don't forget, become a Space Watcher. Thank you.
Thank you. Bye.